Hello, my name is attorney Masa Sam Foray, and I am founder of the Foray firm with offices in Chicago and in Houston. And I am back again today to answer all of your Illinois family law matters. So today's question is, what is discovery? So discovery is literally the process by which we determine and discover what the income, the assets, the debts are of the other party to litigation. And so when we have a case that involves finances, and that can be a dissolution of marriage, it could be a petition for child support, a motion for maintenance, what we'll do is we will issue discovery to the other side because oftentimes the left hand doesn't know what the right hand is doing, and the left hand doesn't know the assets and the income and the debts of the other side. And so the only way to get that information is to ask, or rather is to conduct discovery. So you can imagine that because we're asking oftentimes for years worth of information, that can translate into thousands of pages worth of documents. Discovery is often the bane of your existence as a litigant and as a client, and it is the bane of the existence of many family law attorneys. It's really, really time consuming, guys, and we get it. Nevertheless, it is mandatory and it is necessary if you want to make sure that your child support is properly calculated, if you want to make sure that the court knows all of the debts and all of the assets and everything that is at stake as it pertains to the marital estate. If you want the court to be able to make a decision that is fair and equitable on your behalf, you have to comply with discovery and you have to tender discovery to the other side. Don't presume for 1 minute that you just know everything there is to know about the other side. And don't rely upon them being full and open and candid about their debts or their assets. You need to do discovery. So what is discovery? Well, discovery is sort of the umbrella. Or it's the house, but we have a lot of tools in that tool house. One common discovery tool, and probably the two most common discovery tools that go hand in hand, are requests to produce, also otherwise known as notices to produce or requests for production. But in any event, that's when we're asking somebody to tender documentation. And interrogatories. Interrogatories are questions that we're asking as it pertains to their income. So a sample interrogatory might be, what is your primary source of income? What employers have you had for the last 5 years? Where do you bank? What vehicles do you have? What are their make and the model of the vehicle? Whose name is the vehicle entitled in? So you'll ask any number of different questions to try to understand the totality of the situation. And then from there, once you've gotten your responses to the request for production of documentation, and you've gotten your responses to the interrogatories, most good attorneys will then send corresponding subpoenas. So, by way of example, in the request to produce, I might ask for you to produce all of your bank statements for every account associated with your Social Security number. I'll also ask you in the interrogatories, what are all the places where you bank? And then I'll send out a subpoena when you've responded to me to the bank, and to make sure that what you're telling me is correct and accurate. It's a good way to discover the information when you use these tools in tandem with one another. Another common, set of discovery tools would be in custody or allocation of parental responsibilities cases. We might issue what we call custody interrogatories. So, as opposed to the financial interrogatories that ask about all of the banking and financial history and the assets of the individual, custody interrogatories are a very, very powerful tool for experienced custody attorneys to use to ask about who historically has been the primary caregiver. And of course, the point of these questions, which should be tailored to your specific question, your specific case, are what is in the child's best interest? What has the status quo been? Who has primarily been responsible for these decisions? What are some issues that the court should be aware of as it pertains to the ability of the other side to effectively parent the child? And those custody interrogatories can then form the basis of a deposition. They can form the basis of cross-examination at trial. And so again, all of these tools are incredibly powerful. Speaking of depositions, if you've watched any law movie or legal movie, any, Hollywood blockbuster where somebody was being questioned, prior to going to court, people are often deposed. And so a deposition is literally a questioning of somebody under oath. Depositions are extremely powerful, guys. And the reason for this is when you go to court, there are certain rules of evidence that we are all obligated to adhere to. And a prime example of that, and one that probably readily comes to mind for most people, whether you're an attorney or not, is the rules concerning hearsay, right? So out of court statements that are submitted for the truth of the matter asserted are hearsay. And so there's a number of different rules that not only prevent hearsay, but also give the exceptions to hearsay. Nevertheless, when you're in court as an attorney, you have to be very careful about how you question somebody, and the type of testimony that you can elicit is limited because of the hearsay rules and because of the rules of evidence. In a deposition, it's not to say that we don't follow the laws or we don't follow the rules. However, in a deposition, there's no judge there to make a ruling on the objections. And so while the attorney who's representing the person who is under oath can object, they can object, and that's just an objection for the record, for the court reporter to take down. And then the client still has to answer the question. So think about that. In court, the judge would have shut you down if you asked for hearsay. You would not be able to continue down that line of questioning. In a deposition, you can dig and dig. You can dive deeper and deeper. You can fish a little bit if there's something that you're not quite certain about, to get clarity on it, to then inform you about how to cross-examine them in front of the judge. Very, very powerful tools. So I started by saying this, and I will say it once again because it's true. Discovery can be difficult. It can be time-consuming. In fact, in a divorce case, it's often the most time-consuming portion of any contested divorce litigation. Nevertheless, it is mandatory. You must comply with it. And if you want a fair outcome in your case, you should want to comply with it. I hope that this answers your question, and I look forward to seeing you on the next video.